Hi, Gary DeWaal here, and this is Bridging the Week for December 2nd through 6th, and today is December 9th, 2013. Good morning. This promises to be a very important week in Washington, D.C., as the Commodity Futures Trading Commission and other federal agencies announce how they will institute the Volcker Rule and limit the proprietary trading activities of banks going forward. The CFTC will also consider its important block trader rules. However, the potential importance of this week should not overshadow last week that saw some very significant domestic and international developments too, including a very big lawsuit against the CFTC related to its cross-border guidance. So let's get going covering all these developments on both sides of the Atlantic Ocean and a few up north in Canada too. Last week, 3 financial markets industry organizations asked a U.S. federal court in Washington, D.C. to set aside the U.S. Commodity Futures Trading Commission's July 26, 2013 cross-border guidance and subsequent advisories related to the handling of participants and transactions involved in the global swaps market. The plaintiffs alleged that the CFTC endeavored to masquerade what really were rules by calling them guidance in order to avoid strict legal requirements related to the proposed promulgation of new rules, including, among other matters, adequately evaluating the proposed rules' prospective costs and benefits. The 3 industry organizations were the Securities Industry and Financial Markets Association, the International Swaps and Derivatives Association, and the Institute of International Bankers. Among other arguments in support of its position, the lawsuit contrasts the method by which the U.S. Securities and Exchange Commission has proposed to apply internationally those provisions of Title VII over which it has jurisdiction, mainly through a formal rule proposal subject to notice and comment that includes an analysis of costs and benefits, with how the CFTC has applied provisions over which it has jurisdiction, mainly through a purported guidance. In addition, the lawsuit points out numerous occasions where the Commission itself, as well as its chairman, Gary Gensler, in public speeches, has referred to the cross-border guidance as a rule despite its release as a guidance. The lawsuit also claims that the cross-border guidance undermines international cooperation related to the G20 commitment to augment oversight of the international swaps market through unilateral extraterritorial regulation by the CFTC, quote, which often duplicates or conflicts with foreign regulatory requirements, end of quote, and detrimentally may harm worldwide markets. I have to say that the complaint in this lawsuit should be winter recess reading for everyone. There are really many compelling arguments. By the way, ironically, last week while the 3 industry organizations were in court, CFTC Commissioner O'Malia blistered the cross-border guidance in a speech before the 9th Annual Futures and Industry Association Asia Derivatives Conference held in Singapore. In his keynote address, Commissioner O'Malia challenged the authority of the CFTC to issue the guidance, as well as some of the perceived dangers it endeavors to address. According to the Commissioner, quote, "Let me be clear. It is time to end this regulatory insanity. The Commission must provide a clear notice of the contours of its regulatory reach. Congress explicitly limited the extraterritorial application of the Commission's jurisdiction to foreign transactions that, quote, have a direct and significant connection with activities in or effect on commerce of the United States," end of quote. So far, the Commission has failed to demonstrate any restraint or to validate how our rules comply with this congressional directive, end of quote, to Commissioner O'Malia's entire statement. Wow. In connection with the benchmark indices whose problems keep on giving, the European Commission last week issued fines totaling 1.71 billion euros against 6 worldwide financial institutions for engaging in anti-competitive behavior related to rate setting of the LIBOR, or the London International Offered Rate, and EURIBOR, the Euro Interbank Offered Rate, benchmark indices. Unlike previous actions against financial institutions by financial regulators, such as the CFTC and the UK Financial Conduct Authority, which principally related to alleged manipulation of such indices, this action relates to the alleged collusion among the named entities that, according to the EC, quote, are supposed to be competing with each other. End of quote. Four of the institutions, Deutsche Bank, Societe Generale, and RBS, were fined for anti-competitive conduct related to indices settled in the euro currencies. By the way, that's three institutions. While five, RBS, Deutsche Bank, JP Morgan, Citigroup, and RP Martin, were fined for anti-competitive conduct involving indices settled in Japanese yen. Individual firm fines range from a high of 725.36 million euros for Deutsche Bank to 247,000 euros to RP Martin. Two banks, Barclays and UBS, were cited for engaging in anti-competitive behavior but not sanctioned, as they were given credit for their extensive cooperation. Most worrisome for the industry, the EC says that after resolution of this matter, it maintains ongoing investigations regarding other anti-competitive behavior in connection with benchmark indices denominated in Swiss francs, as well as other financial products, including credit default swaps and foreign exchange, as well as other benchmarks, including in the field of oil and biofuels. You may recall that earlier this year, the CFTC filed and settled an enforcement action against Matthew Taylor, a former trader at Goldman Sachs and Company, related to his December 2000 scheme to enter fictitious trades into the firm's operation systems in order to disguise certain unauthorized futures transactions. As a result of Mr. Taylor's trading, Goldman Sachs sustained a loss of $118 million and itself agreed to pay a fine to the CFTC of $1.5 million for failure to supervise. Mr. Taylor agreed to pay a fine of $500 among other sanctions. Last Friday, Mr. Taylor was sentenced to 9 months in prison and other sanctions following his plea of guilty during April 2013 in a criminal action in this matter filed by the U.S. Attorney's Office in New York. The media has reported that the presiding judge, the Honorable William Pauley, in his oral comments at the sentencing hearing, was very critical not only of Mr. Taylor, but of Goldman Sachs, the CFTC, and the prosecutors in handling this matter. In connection with the regulators, specifically, says Reuters, in summarizing Mr. Pauley's comments, quote, "It cannot be called justice or oversight when it took the government 6 years to bring a rogue trader to justice, when the trader admitted his conduct on day one. At some point, the justice needs to be swift if it's going to mean anything other than another press release and the ability to say, another pelt," end of quote. That's pretty tough. And briefly, the 12 Canadian securities administrators are seeking comment on proposed changes to registration rules potentially impacting dealers, advisors, and investment fund managers that conduct business with Canadian persons. Among other matters, the proposed rules address enhanced proficiency requirements for registrants, what activities may be conducted under the exempt market dealer registration category, and conflicts of interest of registered representatives. At least in some instances, proposed amendments include proposed changes to registration provisions related to those offering and selling futures contracts. Comments are due by March 5, 2014. The U.S. Board of Governors of the Federal Reserve issued guidance last week regarding how banks under its authority should manage the retention and oversight of third-party service providers. In general, the Fed said, financial institutions should maintain an appropriate service provider risk management program in connection with their use of third parties retained through a contract that provide any business function or activity. Such functions or activities might include accounting, appraisal management, human resources, internal audit, loan review, or loan servicing, among other functions. Effective programs, says the Fed, should contain risk assessments, due diligence, review of contract provisions, review of incentive compensation, oversight and monitoring, and consideration of the service provider's business continuity planning. There was EMIR in Europe, and now there is UMIR in Canada. I guess what can you expect from an industry that also has SIFMA? The Investment Industry Regulatory Organization of Canada, or IROC, as opposed to DeWaal's, reminded its members of new requirements for third parties directly accessing equity markets in Canada as of March 1st, 2014, under its Universal Market Integrity Rules, or again, UMIR. These rules, which generally aim to enhance standards to manage risk associated with direct electronic access, will require a formal written agreement between an exchange participant and its client to which provide access, and so-called gatekeeping procedures that require reporting to IROC of non-compliance by the client with any requirements of the written agreement or the relevant UMIR provision. There are specific requirements related to information in the form and how it is sent. Well, that's it for Bridging the Week this week. There are always more stories on the article version of Bridging the Week on my website, so check it out. Until next week, when we know for sure how proprietary trading by banks will be restricted by regulators, this is Gary DeWaal, and this has been Bridging the Week. Thank you, and have a great week. Ciao!